Hi, Tim Blankenship here with Divorce661.com. I wanted to just let folks know, and this is in regards to default. So in a divorce in California, when you file for divorce, the other party has 30 days to file a response. If that party doesn't file a response, the other party can file what's called a default or a request to enter default, and it will basically kick the other party out from being able to participate. Well, we had a client come in who thought his wife was being fair and honest with him, and they were trying to go through an amicable divorce, and he was being told by her attorney that he was going to be included and there was no need to file a response. And so he was going along, and he wasn't filing a response as the attorney instructed him. And what they did instead was, from what we could figure out, is in looking at the case summaries, they tried to trick him in not filing a response so they could file a default on him and basically kick him out of the case. And the reason they were doing this is because she had petitioned for, in her petition, she filed for full legal and full physical custody. But she was telling him that he would get joint custody in their agreement and that that's what the attorney was drafting. Well, when he called our office, we ran a case summary and we saw that not only did they file the request to enter default, but they had also filed the judgment. And I had to tell him, basically, she's going to get everything she asked for in the petition, which in this case specifically, his concern was that she was going to get full legal and full physical custody. So here's the point of the story. When a default is filed, when you look at the case summary, which we did, we could see that a week ago that the default had been entered in the case summary. That doesn't mean necessarily that it was entered by the court, like the default has not been entered. So two steps happen here. One is they will, when they receive the paperwork, they will put it in the system, but then it has to still go to the judge or the court clerk to sign off on the judgment, because the case has to be reviewed to make sure things were done in a specific order, and then they'll enter the default. So we called the clerk in the courtroom, which is what you'll have to do, and asked if the default had actually been entered, and they said no, it had not been entered, only marked as received. So of course what we did is had our client, we filed his response immediately, and now he's in the case, and basically that's going to make them have to include him and as a participant in the agreement, because now he's officially responded and officially part of the case. So just be aware, if you're going to go through an amicable case, that it's being done correctly, and you need to trust but verify, especially if there's an attorney on the other end. We're not saying all attorneys do this, of course, but in this particular case, it seemed like they were trying to pull a quick one on him, but we were able to jump in literally at the last minute and kind of save the day to at least allow him to respond and be able to participate in the divorce and hopefully get equal access and custody to his children. All right, Tim Blankenship, Divorce661.com, specializing in California divorce. Please feel free to give us a call. Be happy to provide you with a free phone consultation if you need assistance with your divorce. 661-281-0266.